Soundbites. My name is Stephen Reagan, and I'm the principal privacy consultant and subject matter expert on privacy and data protection law at Rangu. With these soundbites, I like to give an update of some things that are going on in the privacy and data protection world. And today I want to think a bit about innovative technologies like artificial intelligence and machine learning, and explore how those are regulated under the General Data Protection Regulation, how we can use the GDPR as a framework for developing innovative technologies. Because of course, we have the proposed AI Act in its consultation phase. It's not exactly clear when that will be coming out, but that will be in some sense an innovative legislation looking at regulating these technologies. But in certain situations, these technologies are already forced to comply with the General Data Protection Regulation. So I will look at some of the situations under which the GDPR regulates these technologies, and also explore how we can use the principle-based approach to, in some sense, develop these innovative technologies while really keeping in mind that emphasis on human rights, privacy, and data protection. So of course, under the GDPR, we have to think about a lot of things. Okay, there are over 80 articles in the regulation, and organizations who fall within the scope of the GDPR have to keep those privacy policies, privacy notices in place, comply with those requirements under Articles 13 and 14. Concerned with that transparency principle, telling the data subject what is being done with their data, why it's being processed, what is the purpose of the processing, how long it's going to be processed for, how they can facilitate and access their data subject rights. So really looking to empower data subjects and give them some type of agency and control over the uses of their personal information. Because then we have to have a legal basis to process personal information, consent, legitimate interest, contract, all of those possibilities under Article 6. Organizations also have to be keeping records of processing activities, and in some situations, conducting data protection impact assessments. So these risk assessments in uses of new technologies is something that organizations should probably be doing. Under the GDPR, it's a balancing approach. So weighing the benefits of the uses of the technology, of the processing activities, weighed against those risks to the rights and freedoms of data subjects. Risk assessments will form a large component of the AI Act, and is something that organizations can already be documenting and put in place. And so, again, we're drawing some lessons from the GDPR for how potential regulations will regulate or categorize these new technologies. So when does artificial intelligence fall under the GDPR? When you are processing personal data, and that type of data is information related to an identified or identifiable individual. So when there's processing of personal information in order to, make predictive analysis or train machine learning or artificial intelligence, this also falls under the scope of the GDPR, and in such situations, organizations have to comply with the regulation. So I've already mentioned this term a number of times, processing. So what does that mean? Processing is defined under Article 4 really as any operation or set of operations such as collection, recording, analyzing, structuring, storing, transferring, anything that you can think of to do with personal information falls under this definition of processing. And that includes adaptation or alteration, because one of these interesting proposals for dealing with these challenges under the regulation is to, in some sense, make the personal information unidentifiable. And if the personal data, the personal information no longer relates to an individual, then in some sense you fall outside of the scope of the GDPR and can really do what you want with that personal information that is, in some sense, no longer personal information. And so where does this come from? Well, this comes from recital 26, which addresses the conditions under which a piece of data which is not explicitly linked to a person may or may not count as personal data. This all relates to the concept of identifiability, which depends on the availability of quote unquote means reasonably likely to be used for re-identification, looking at objective factors such as cost, time, and available technologies. So really what I'm thinking about right now is taking this personal information and converting it or anonymizing it, and then that puts you were inside the scope of the GDPR, processing personal information for innovative types of uses of technologies, anonymizing that data, making it unidentifiable and unable to be re-identified. Okay, then in some sense there's the chance that you fall outside of the scope of the GDPR and then are not constrained by the regulation. The Information Commissioner's Office in the UK is currently undergoing a consultation on this very issue and thinking about ways that the supervisory authorities can assist organizations in making this determination about re-identifiability. Because, again, if we remove the identifiers, we remove the risks to the individual associated with misuses of data or data breach or these other concerns that the regulations are trying to solve. So beyond that, we can look at when we are processing personal information, look at the principles of the GDPR as a kind of guiding frame for the development of technologies. So the principles are listed under Article 5 of the GDPR, and I will just go through them here. The first principle is lawfulness, fairness, and transparency. So data must be processed in a manner that is lawful, fair, and in a transparent manner. This has a lot to do with keeping those privacy policies up to date, but it also presents real challenges for organizations using these new technologies, which in some sense, they're like inputs of personal information. Something magical happens, right? That's this black box effect, and then we get an output that in some sense might be hard to define, and then it really makes it a challenge for conveying the uses of personal information, the logic used to make decisions with that personal information. So organizations really need to be thinking about the ways to describe the processing activities and conveying that in a manner to individuals in a understandable manner. And that is, in a sense, to, again, give agency and control to data subjects over their uses of their personal information. So another challenge related to the principles is purpose limitation. And this says that data must be collected for a specified, explicit, and legitimate purpose, and not further processed in a manner that is incompatible with those purposes. So this really constrains, again, the uses of that personal information from processing activities that were unforeseen. But this forces organizations to really consider why they want to use that personal information and what the outcomes and goals are of their processing activities. Another challenge, data minimization. So personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which the personal information is being processed. So again, we are limited with our purposes of the processing activities, and we are limited with how much data we can use to process, or how much data we can use in our processing activities. That being said, we can almost reinterpret this principle, say that, machine learning, these processes are really data hungry. They need a lot of data to train on. All right, well, we can say then perhaps that that is a justification for needing large data sets in order to train these innovative technologies. Whether or not that complies with the spirit of the regulation is an open question, but nonetheless, we really want to be looking at ways that we can be innovative, ways that we can do new and interesting things to help society going into the future. So have those benefits really outweigh those potential risks in that risk assessment that is laid out in that data protection impact assessment under the GDPR. The next principle I want to mention is accuracy. So of course, data must be accurate and kept up to date. If we are processing personal information with inaccurate data, then our outcomes are not going to reflect the real situation, and they are going to be less useful and less effective. This is a really a big threat to data subjects when there is processing of their information that is inaccurate personal information. So again, thinking about that, let's think about this example of credit worthiness. So say you go to a bank and want to get a loan. The bank has your loan history, and unfortunately it's not up to date, it's not accurate. So the last 3 loans that you have gotten haven't been paid, and that's not true, right? You've paid these loans, but nonetheless the bank is not going to loan you more money given that given the perceived past history. So again, really want to keep that data up to date, accurate. The next principle I want to discuss is data storage limitations. So again, another limitation on uses of personal information. You cannot keep personal information for undefined periods of time. You can only keep data as long as you need to achieve that purpose that we've already mentioned. Now, this also runs up against there are in some cases statutory obligations to keep personal information for a certain amount of time. So it is important for organizations to be also aware of that. What are the local rules and regulations related to to maintaining personal information? Then we have integrity and confidentiality. Okay, those relate to security and the technical and organizational measures that are in place. And the last principle is accountability. So organizations have to be able to demonstrate compliance with these principles and with all of the other articles under the GDPR, even when you are processing personal information for artificial intelligence, machine learning. Organizations doing this need to be aware that they also fall under the scope of the GDPR. And with that, I want to thank you for tuning in. I hope this gives a bit of background on those principles of the regulation, kind of a little bit of the spirit of the GDPR and how that can be used as a guide for developments of new types of technologies that comply with the GDPR, but also prepare for that future regulation of artificial intelligence, at least here in the EU. So have a good rest of your day, and I will see you next time.